Hi, I'm Stuart Clark.
And I'm Charlotte McGee.
And welcome to Hull on Estates. You are listening to episode number 571. Hello, Charlotte.
Hello, Stuart.
It's our first time podcasting together.
It is, and my first time podcasting ever.
Well, welcome to the lovely world of Hull on Estates podcasting. You're going to become internet famous. You're going to walk down the street. People go, hey, that's that Charlotte McGee. Yeah. I saw her on the internet. She was talking about the estates and stuff.
I know, that's the dream. That's really the goal here for sure. So really looking forward to it.
Well, happy to be your first podcasting partner here, and I guess onwards with the show.
Sounds good to me.
So today we're talking about it's a concept. We're not doing the whole, hey, here's a case, let's break it down. This is more of an issue that comes up semi-frequently in estates-related matters, and the basic issue is how can you in fact even bind non-signatories to a settlement? Mm-hmm. Now that sounds kind of boring and abstract, but I'll kind of break it down to why from a practical level this actually is an issue that comes up quite a bit. Mm-hmm. So in estate litigation, often there are lots of parties in a will, right? You could have dozens of parties in a will, not all of whom may theoretically actually be participating in the litigation. Mm-hmm. So if you are litigating this estate fight, you're more often than not, if you're the challenging party, litigating it with either the estate trustee or a couple beneficiaries who are really engaged in the litigation with you, but a lot of other people may not. They may be disinterested. They may say, you know what, I trust you guys, you fight this thing out, and maybe I'll come back later on, but maybe not. So that's fine if you're going away to the trial, because the judge can say, okay, I decree X, Y, or Z, and now this is how the way all the cards are going to fall. But most litigation now settles before you get to a trial, because the trials is so expensive to get to. So the question is, how can you bind those parties who are kind of disinterested or not participating in the litigation to a settlement, when a settlement at its core is basically a contract, right? A settlement is basically, okay, we collectively agree to do X, and we won't go to a judge and make them decide. Well, if everyone who has an interest in that pie doesn't say, yeah, I'm cool with X, can you do X?
Right.
And the answer, of course, is, well, it depends.
Yes.
But yes, there are scenarios where you can play it out.
Well, and I think that the real crux, too, that you're identifying here is just because someone isn't interested in participating in the litigation doesn't necessarily mean that their interests wouldn't be affected by a potential settlement.
Exactly.
Right.
No, that's exactly it, right? So, I mean, it's not hard to imagine, say, a scenario where there are 4 residuary beneficiaries. Mm-hmm. You're litigating with one of them, but one of them is kind of off in this distance, not talking to you.
Right.
If you're paying out a settlement to a dependent, to a will challenge person, okay, here's a lump sum check of $100,000. That $100,000, unless you structure the settlement only to be from the people who are actually participating, is going to take money out of the pie of the residuary beneficiary. Their interest is being affected by the settlement. Can you do that?
Right.
And so the answer, of course, the first one is, well, yes. Trustee Act. So the Trustee Act, and it's specific, Section 48 sub 2 of the Trustee Act gives the broad power to the estate trustee to settle claims on behalf of the estate. So if someone, including someone, a dependent or a will challenger, but also in theory, Visa. If Visa is suing you because the dead person owed them $10,000 and they're willing to cut a deal for $6,000,
right.
The estate trustee under Section 48.2 is allowed to settle, and I'm air quotes here, claims on behalf of the estate with those parties.
Right.
And it binds the estate. It binds everyone. It binds all the beneficiaries. And from the third party's perspective, it's now a good settlement. It is that is all that is required, a settlement with the estate trustee.
Right.
But, there's a but, if you're the estate trustee, doing so is not necessarily completely without risk. So the Trustee Act says that the estate trustee can do this, but that they're only insulated from liability as relates to the beneficiaries in doing so if the settlement was entered into, and again, air quotes here, in good faith. And so, of course, that implies, well, what does that mean?
Yes, that's correct. And so in noting up this section, prior to coming to this podcast, I looked at a couple of cases, and I think while good faith sometimes can be a bit of an amorphous concept, the one thing that I found was that just because beneficiaries or potentially interested parties would disagree with the settlement that was being entered into doesn't necessarily mean that it's entered into in bad faith per se, such that it wouldn't be protecting the estate trustee from liability. So in the case, the Ontario PGT and Rzadkowski estate.
That's close enough.
Yeah, I did try to practice that beforehand, and that was my best shot. So please bear with me here. But the court did note that while counsel maybe had been objecting to it, they presented no evidence that suggested that the settlement was actually made in bad faith. And in kind of assessing that, the court noticed that there had been logic behind the settlement and that it reflected a reasoned analysis of risk, including the time that would have otherwise been required to resolve matters by court order and the cost of doing so. So to me, that just kind of suggests that it almost is a little bit of a common sense thing, this good faith concept. And similarly, in another case, Dunn and Dunn estate, when the court was assessing whether or not the executors were able to enter into this settlement, the speaking judge noted that the executors had carefully weighed the pros and cons of settling the litigation and had thus decided to settle. So again, it just kind of seems that it's sort of so long as you're taking into account things in a kind of rational way, that could be connected to this concept of good faith.
And I think that's exactly it, right? I mean, it is kind of a loose concept on a case-by-case basis.
Right.
And it comes down to, does this settlement make sense? Can a person look at that and go, yeah, I get that. Yeah, there was some risk there was some cost of litigation associated. What's the estate trustee's rationale or reasoning behind entering into it? If it's, this is going to cost the estate a ton of money. There's a little bit of risk here, and I'm willing to cut a check for X dollars. That probably makes sense.
Yeah.
If, however, it's, heck, the estate trustee may have messed up on something and they're only getting the settlement to save their own butt.
Yes.
I mean, maybe that's not good faith. Maybe the beneficiaries there go, hey, wait a second. And if the beneficiaries do go, hey, wait a second, it's often done later on like a passing of accounts. They say, hey, wait a second, what's that check for $200,000 I see there in your account? Settlement. What was that? And you say, I entered into a settlement with someone. Don't worry about it. But if, they could try to then unravel it. But if it was done in good faith, again, air quotes, you're cool. Beneficiaries can object, but the court should, in theory, say, you know what, that was done in good faith. Trustee X says you can do that. Beneficiaries are out of luck. Go away.
Right.
But if it's not, if the court finds, you know what, that wasn't done in good faith, the settlement could, in theory, all unravel. And since the check's already left the barn door at that point, it's running away.
Yeah.
And the estate's now down, whatever the settlement was. In theory, the estate trustee could be liable to the beneficiaries for that payment.
Right.
Which, of course, even if that's a minuscule, small percentage chance, a lot of estate trustees go, well, why the heck am I putting my neck out here on the line? Mm-hmm. I'm entering a settlement. Yes, maybe it makes the most sense. Yes, maybe it's the easiest way to kind of bind this estate to the settlement. But I'm at risk here. I want the beneficiaries to sign off on the settlement as well so they can't yell at me down the road.
Right.
Which is fine if the beneficiaries are all saying, yeah, cool, we'll sign off. But what if, as we talked before, you can't kind of herd all of the beneficiaries together to the settlement? Are there other ways you combine these non-signatories? Or if the estate trustee says, you know what, I'm not signing off at all, you guys go rope the beneficiaries in. So way two, again, which is included on in limited circumstances, is if there's a minor or an incapable person who is not a signatory to the settlement, you can use Rule 7.08 of the Rules of Procedure, which provides that a settlement can be approved, again, air quotes, on behalf of that incapable party by the court. And the court literally steps into the shoes of the incapable person. They're supposed to ask, hey, is this settlement in the best interest, again, air quotes, of the beneficiary or of the party who I'm approving the settlement on behalf of? And if yes, then cool, order goes approving it on behalf of that party. Settlement now binds that party. But if they say no, it's not in the best interest, then obviously they're not bound by the settlement.
Right. Well, and in that case too, my understanding is that it's not even just that 7.08 is a permissive rule for the court, for permitting them to consent. It would be required for a party under disability to have that settlement be approved by the court.
You're 100% right. So a settlement can't bind a party unless Rule 7.8 is used and it's approved on behalf of the court.
Right.
So, there's some wiggle room there potentially. If it's the trustee act, because technically the trustee act can just bind everyone, and then in theory the minor beneficiaries could just sue the estate trustee saying that was a bad deal.
Fair.
But if it's a settlement that you're actually saying, hey, I want this approved on behalf of minor beneficiary X, Y, or Z, I want to vary this,
right,
then in theory you need to go under 7.8 and you need this consent of the court. But 7.8 is only available if there's an incapable party. You can't just do it because, Uncle Steve isn't willing to sign off on the agreement. You can't go, well, I want to approve this on behalf of Uncle Steve.
Right.
Well, if he's not incapable, you're out of luck.
Yeah, or unless Uncle Steve is 11 years old and is a minor or something to that effect. But that's probably that fact scenario is not going to come to light.
We don't judge.
No.
And this kind of comes not a pet peeve. I suppose it's a pet peeve. Often things are thrown around. I always hear, we'll just approve that settlement on behalf of everyone who's not a signatory. And the word approve is kind of the Rule 7.8, which is available, as we said before, in very limited circumstances. The court has no authority, and they're under the rules, to approve a settlement on behalf of someone who is an incapable. What you can do, however, potentially, is then option 3, which is you can try to seek judgment in accordance with the settlement. Now, technically, you're not settling or approving, rather, the claim on behalf of anyone, but rather you're going back to court saying, okay, we have a settlement. Everyone hasn't signed off on this, but we think it's a good deal. Can you please issue a judgment in accordance with the terms of the settlement? If the court says yes, then you're basically rebroadcasting the settlement as a court order. And since a court order binds, the universe,
Right.
You're cool again, and you've now bound these parties who aren't signatories. This whole process is a little bit, vague, we'll call it. There's no rule that allows you to do this. There's no statute that kind of contemplates this approval on behalf, or judgment in accordance with the settlement. But you often see it brought up as just a common sense way to kind of push a settlement through if the estate trustee isn't willing to bind the estate, or it's a novel set of circumstances where you need to kind of rope in parties who might not be willing to consent to it. And that's kind of it. So I've seen it done a couple ways. You often see, so if you think you're going to have this problem down the road, i.e. not be able to rope in all the beneficiaries, at the earliest stage of even getting the order given directions at the first attendance, you could in theory build into the order something like, look, any settlement reached on mediation is going to be conditional upon you later getting judgment in accordance with the settlement. And you can even spell out, kind of some not cheats, but some ways to make it easier for you, even saying, look, we'll need to give notice in writing, or by mail, rather. We don't have to actually physically go out and personally serve you again.
Right.
You can contemplate how expansive the class of people you have to serve is. But the basic concept here is, look, we can go out into the, we get the settlement with the people who are participating. If the state trustee isn't willing to bind the whole estate under 48 of the Trustee Act, we then get this judgment, rebroadcasting it. And I personally think it has to be brought on notice to all beneficiaries who are affected by it, or all parties, I should say, who are affected by it. Some people have said, you know what, you give up your right to complain if you don't file notice of appearance, and I can see some rationale there, but the safest route, at least from my own perspective, is serve the people who are affected by it, and if they don't say anything and judgment gets issued, well, hey, cool.
Yeah, then at least
we've now bound you to a judgment.
Yes. No, I agree with that. I definitely do, and I think it would be interesting to try to wrap that up without putting the beneficiaries on notice. I think
I've seen it done a couple times. Again, this is not what I like to do, but I've seen people build into their orders. Basically, they will say, hey, the parties are to attend mediation on XY date. Here's the mediator. And by the way, any settlement reached at mediation shall bind the interests of any beneficiaries who are not signatories. And I've seen that that order rather be issued.
Right.
I personally have a little bit of issue with it because I at least question whether or not the court can preemptively almost prove or to give judgment in accordance with a settlement that hasn't even been reached yet.
Right.
Because settlement hasn't even been done yet. The mediation hasn't happened, and where you don't even at least put it under the nose of the people who could be affected, saying, hey, did you have any issues with this? I've seen it done. Maybe they get held up. I don't know. But the safest route would probably be to serve everyone.
And would there ever be some sort of a scenario where the beneficiaries would see that sort of language used and think, hey, wait a minute, and that would incite them potentially to get involved?
Maybe. Who knows? You're of course assuming that people pay that much attention to stuff that, comes in the mail.
Fair point.
You often see the same thing. These orders, you often see, this order must be served on all parties by mail and that kind of stuff.
Right.
And that's why you're doing that. You're doing that so that you kind of say, hey guys, we're telling you about this process here. If you want to jump in now, now's the time.
Yeah.
And if they don't do that and judgment eventually gets issued in accordance with the settlement, I think there'd be an argument that they're bound. But as I said, the safest route is to be, hey guys, we got a settlement. This is it.
Yeah.
We're going to get judgment in accordance with this.
So to say your piece, or just this is what's going on. So no, that's very fair.
And that's basically it. So yes, there are ways, magic ways, to bind non-signatories to a settlement. You can go into the Trustee Act and come on, estate trustee, this is a good deal. Put your neck on the line a bit and enter it in the contract. If they're a minor or incapable beneficiary, you can go into 7.8. Or as a broad kind of catch-all, you just get judgment in accordance with settlement, and hopefully, if it's done, you bind all non-signatories. So huzzah! There are ways to bind non-signatories to a settlement. We have solved all of the world's problems. Charlotte, it has been a pleasure. Thank you for doing your first podcast with me today.
Thank you, Stuart.
And that concludes our podcast. So again, I want to thank you for listening. I'm Stuart Clark.
And I'm Charlotte McGee.
And should you have any questions, please email us at webmaster@hullandhall.com or leave a comment on our blog. Thank you very much.